Hello and welcome to the James Wilson Institute and the Center on Religion, Culture, and Democracy Zoom webinar titled Bilateral Judicial Reform 10 Neutral Proposals that Would Equally Weaken the Right and the Left. Before we begin, some housekeeping items. And for those of you listening on the Anchoring Truths podcast, I'm your host, Garrett Snedeker. Today's webinar conference is being recorded. During today's interactive webinar, I and Daniel Osborne of the James Wilson Institute will keep a queue for asking questions. Please utilize the Q&A feature by hovering your cursor over the middle of the screen and clicking on the icon at the bottom that says Q&A. You're encouraged to submit questions via Q&A during the Q&A portion of our program towards the latter part of the hour. The staff will alert you when you're next to speak and prompt you when you should be ready to ask your question. We'll unmute your Zoom microphone automatically. Your video will not appear, but your audio will be live when asking a question. If you'd prefer to ask your question anonymously, please indicate that in the wording of your question, and our staff would be happy to read your question. You can use the anonymous function in the Q&A, or I'm more than happy to read your question on your behalf. Please use the chat feature on the right of your screen to interact with your fellow attendees and send these messages to Daniel. We are pleased to feature our guest speaker, Professor Josh Blackman. In the height of the politicization of the judicial branch, the federal courts cannot be reformed through unilateral disarmament. Rather, any federal judicial reform must be bilateral. His article, for which this webinar is named, lays out a set of 10 proposals for reducing the power both of the left and the right, and the power that they exert through the judiciary. Josh Blackman is a national thought leader on constitutional law and the United States Supreme Court. His work was quoted during 2 presidential impeachment trials. He's testified before Congress and advises federal and state lawmakers. Josh regularly appears on television, and since 2012, he has served as a professor at the South Texas College of Law in Houston. He holds the Centennial Chair of Constitutional Law there. He is the senior editor of the Heritage Guide to the Constitution, 3rd edition, which, Josh, yes, is right by my side, and it shall always be right by my side. He has written more than 7 dozen law review articles that have been cited more than 1,000 times. He was selected as the Jurist of the Year by the Texas Journal of Law and Public Policy, received the inaugural Mies Originalism Award from the Heritage Foundation, and was awarded the inaugural Joseph Story Award. I think that was from the Federalist Society. Among his many accolades, he is also the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. He blogs at the Volokh Conspiracy and tweets at Josh M. Blackman. We're delighted to have you, Josh, and the floor is yours.
Thank you so much for that. So most debates about judicial reform are predictable and frankly pointless. Progressives aren't happy with the current right-wing judiciary, so they propose reforms that make it harder for conservatives to prevail in court. Conservatives are happy with the current right-wing judiciary, and they oppose reforms that make it harder for conservatives to prevail in court. Lather, rinse, and repeat. Proposals that only help one side of the aisle have slim chances of enactment. Indeed, efforts to address actual judicial emergencies by creating new judgeships stall to avoid granting a windfall of appointments to a single president. The federal courts cannot be reformed through unilateral disarmament. Rather, any federal judicial reform must be bilateral. This podcast offers 10 neutral proposals that would equally weaken the right and the left. These proposals do not need to be adopted as a package. They can be adopted piecemeal or mix and match. Most of these reforms, including expansion of mandatory jurisdiction, would require amendments by statute. Some can be achieved through court rules. I am agnostic here, at least, whether reform comes from Congress or from the courts, but I think it's always better if the courts self-regulate. I'll admit up front that some of these proposals are off the wall, and they're mostly intended to stimulate debate rather than create an actual plan. I think a few of these may create problems with judicial independence and separation of powers, and they might require a constitutional amendment, but I think they would probably be okay without it. But thought experiment at least. There are three values that really inform my proposal here. First, we know there's a sharp decline in the Supreme Court's cert grant rate, and this decline undermines the court's primary role, resolving circuit splits and promoting uniformity of federal law. They're deciding fewer cases while the lower courts have these splits that fester. Second, about the justices. They are cloistered. They're insulated from the lower courts and the American people, and they stay in the job longer than they should. Supreme Court justices and really all federal judges have powerful jobs, cushy perks, have little incentives to retire when the time is right. We can change that, change the incentives. Third, expedited litigation leading to the Supreme Court's emergency docket yields massive confusion, wastes so many resources, and as we've seen, forces judges to make decisions under time constraints. I think many proposals to curb forum shopping and eliminate national edge injunctions are treating the symptoms and not the underlying illness. I suspect, or at least hope, that court watchers of all stripes would agree with these three principles. All right. So let's go to the first grouping of reforms. These concerns the Supreme Court justices. My first proposal, proposal number one, require the justices to ride circuit. Bring back circuit riding. James Wilson rode circuit. Good enough for James Wilson, right? Good enough for all of us. Require the justices to ride circuit, and this is the wrinkle, when the federal courts of appeal sit en banc, the circuit justice presides. All right, let's walk through this. The Chief Justice appoints circuit justices for each of the 12 circuit regional courts. As a matter of custom, the justice is usually appointed from where they're from. For example, Justice Alito is a circuit justice of the Third Circuit. Justice Sotomayor is from New York, so she's the circuit justice of the Second Circuit, and so on. By custom, going all the way back, the Chief Justice presides over the DC and the Fourth Circuit because they were closest to him. But some don't really make sense, right? Why did Justice Scalia and Alito have jurisdiction over the Fifth Circuit? Why is Justice Kagan Circuit Justice of the Ninth Circuit? She's never lived west of the Hudson, right? Um, these are somewhat ideological, having a conservative in the Fifth Circuit and a liberal in the Ninth Circuit, and so on. We can rotate these. In fact, I would actually insist that they rotate. There's no reason why the same justice should always be in charge of one circuit. But beyond the rotation, I would alter the responsibilities of the circuit justice. This is not new. It's restoring of responsibility from the earliest republic. In fact, what does the phrase circuit riding mean? You would have a judge, usually on horseback, riding along the circuit of courts. They go from place to place to place. Is this constitutional? Probably. The Supreme Court more or less upheld this practice in Stewart versus Laird, and I think that is a precedent we can rely upon. The Congress abolished circuit riding in the late 1800s by statute, but there's no reason why it cannot be brought back by statutory regime. And I think the most important attribute of this is that when there's an en banc sitting of the circuit court, the presiding officer will be the circuit justice. This has a few different virtues. First, it forces the justices to become familiar with their colleagues in the lower court, right? Second, it gives the circuit justice boots on the ground. They can see what's going on in the real world and realize where they need to intervene as a justice. Third, the justices can speak to their colleagues in the lower courts, a view from the top, as it were, and shed light on where the Supreme Court is going. Fourth, this is kind of a fun thing, they can be presiding. Most of the justices will never preside in their lives, no matter how senior they are. Justice Thomas has been in the court for almost 35 years. He will never preside unless the Chief Justice is unable to work. Don't know why that would happen. How would this work? I think you need a random lottery. I don't think you can have the same justice sit every year. Fifth, it's good to get the justices out of DC. Go to America. Go to Denver. Go to St. Louis. Go to Cincinnati. Go to Chicago. See what's going on in the rest of the world. All right. My next proposal, proposal number two, concerns money. Now, many of you might have seen Justice Barrett's new book. I've actually written in favor about it. I like the book. It's a good book. But I have a problem with the book. As you all know, the justices have fixed salaries, about $200,000 per year, and federal judges have a limit on outside income, about $35,000 a year. The number increases a little bit each year. But there's a loophole big enough to drive a Mack truck through. Royalties are not subject to this $35,000 limitation. Royalties can be as much as they can earn. So in recent years, justices have been receiving massive multi-million dollar book advances. And for those of you who haven't published a book, the way it works is with an advance is they're giving you money in anticipation that you will earn these royalties in the future. So one model is you get no advance and they just pay you month by month or quarter by quarter whatever royalties you earn. With an advance, you get this huge lump sum of money, and then eventually you can earn it back. Um, we have no proof that the justices ever actually earned these royalties back. Maybe they do, maybe they don't. We're not really sure. We can maybe try to piece it together through their disclosures, but we're not positive. Another problem is that these advances are basically interest-free loans. You know, with Justice Barrett, she signed the deal back in 2021 or so. Her book came out in 2025. So about 4 years lapsed. That money was sitting in whatever. I think she actually bought a house with it, right? But there was no check on that amount. So I would impose a statutory cap. Whatever royalties you earn are capped at that $35,000. So maybe that means you can't earn more than $35,000 a year. Maybe you can put the extra royalties in a trust somewhere that can be tapped after the justice retires from the bench, or maybe their heirs can inherit it, or do what Justice Holmes did, right? Leave it for the federal government, the Holmes devise. Maybe we'll bring back a benevolence in that fashion. So I think there's virtue there. Also, and this is a bit of a um, personal point, I think the justices have way too much free time in their hands. I do, and that's an awful thing to say. If they're spending less time writing, promoting their books, maybe they can write more opinions and take more cases and do their actual job. So I think their values, as I often say, um, their first job is to be a justice. You know, maybe this makes it harder for them to earn a living. I'm not sympathetic to this claim. Judges in the DC circuit earn even less money and they live in the same locality. They don't have the opportunity to teach at, fancy law school, so I'm just not sympathetic to this claim. Maybe this makes the justices retire sooner to earn more money. Great, right? Article 3 is life tenure, not a life sentence. And the justices can cash out when they step down. All right. My next batch of proposal concerns the Supreme Court's docket, the SCOTUS docket. Proposal number 3. This one they're going to hate. Mandate that the Supreme Court remains in session year round. No more summer vacation. There's at least one public sitting for oral argument and one conference per calendar month. I think every court of appeals in the country has arguments over the summer, right? Um, it's insane that the Supreme Court just wraps up at the end of June and calls it a day till October. They rush through all their opinions, they just get it out, and they get the heck out of town. Now, there might be important social reasons why this works because the term can be very contentious and maybe they need a break from each other. Okay, fine. But the business of the judiciary doesn't stop in the summer months. In fact, emergency applications routinely come to the court over the summer, and the court doesn't have a regularly scheduled argument session, and they don't have a regularly scheduled calendar session, a conference to decide matters. So very often these matters that come up, the justices can't hear argument until October, and they can't even discuss with each other in person. If there's a set date in each month where there's oral argument, that could be used to fill in any sort of emergency cases. And if there's a set time where the justices know they have to be there in person for a conference, that can be used to deal with emergency sittings. Um, this one I think would have to be by statute, but I think there's no constitutional problem. The statute currently says the term begins the first Monday in October. It doesn't actually say when the term ends. And as a matter of custom, the Chief Justice usually says something like, "We have now decided all of our cases. The court will recess until the first Monday in October," and so on. We don't have to do that. Again, this would ruin their summer vacations. I'm not sure that's a bad thing. You don't need 2 months off for summer vacation. That's a lot of time. You could stretch the sittings out so you have a couple weeks off in July, a couple weeks off in August. More than enough vacation for the justices. Um, I think it would also eliminate this rush where they feel they have to decide every single case by June 29th, whatever the day happens to be. That benefits no one. They get sloppy at the end, they rush things through. If a case is argued in October, okay, fine, let me decide in June. But if a case is argued in May or April and you want to squeeze that into June, that is not a good idea. All right, so that's proposal number three. Proposal number four, they're not going to like also. I would establish a timeline for review of petitions and applications on the merit, emergency, and capital dockets. Um, so to be fair, I think much of the criticism of the court's emergency docket is overwrought. I will not say shadow docket; it's not a thing. Sorry, Will. The emergency docket. But I think the court has more or less figured out how to handle the emergency docket. It's not great, but I think they've come to something of an equilibrium. Still, the court does not apply what I would say neutral principles to timing. They don't. Um, I would create them. So first, the merits docket has discretionary review of petitions for its certiorari. The emergency docket we know has these non-capital emergency applications for stays, injunction, other relief. And third, we have the capital docket for death penalty cases. Okay. What I would do is establish set periods of how much time they have to resolve a cert petition. There have been times where they sat on a cert petition for nearly a year. What are they doing? I don't know. This happened with the affirmative action case pursuant to fair admission. Dobbs was relisted umpteen times. I would give more certainty to the parties. For the emergency docket, I would also create timelines, standardized timelines. Uh, if an emergency application comes in, how long until a response is called for? How much time does the justice have to respond? How much time do the parties have to respond? And when will an issue be resolved? Some emergency applications, you have 24 hours to respond. Sometimes 3 days, sometimes 7 days, sometimes 14 days. Sometimes an emergency application can be pending for a month with no resolution. I realize the justices have a lot of stuff on their docket, but I think it's to everyone's benefit to have clear guidelines of how long these things take. Okay. Proposal number five. We're at halfway done. We're almost there, everyone. Um, this concerns oral argument. When a case is in the Supreme Court's mandatory jurisdiction, oral argument is required. So to start, the court's mandatory jurisdiction means they have to take the case. There are only a small number of cases that fit in this category. One category involves original jurisdiction cases, where usually a state sues another state, invariably at water rights. This is what's called the court's mandatory jurisdiction. There are also certain voting rights cases that are mandatory jurisdiction, and certain campaign finance cases that are mandatory jurisdiction. But the court does something a little funky. They don't actually set these cases for oral argument. By my count, almost 40% of these mandatory cases are resolved without oral argument. The court will just summarily affirm the lower court. I think this is a slap in the face to Congress. If Congress decides that some jurisdiction is mandatory, I think the court should at least hold oral argument. And I would therefore mandate that the Supreme Court hold this oral argument. Okay. The next category of proposals, 6 through 10, concern reforms in the lower courts. Um, my proposal number 6 concerns TROs. And I think this one will be extremely timely in light of what's going on in Boston and other places. Cases seeking a temporary restraining order can be decided by a single district court judge, but can only yield relief to the named parties and are limited to no more than 7 days in duration. So again, when you're seeking a TRO, relief is limited to the named parties and for 7 days. And I think, oh, Josh, didn't the Supreme Court's CASA decision resolve this? Not exactly. Um, the Supreme Court touched what's called the national injunction, but they didn't touch what's often called vacatur or set aside under APA Section 706. I think I would take Congress a step further and specifically say relief is only limited to the named parties for a TRO, temporary restraining order, and limited to 7 days. All right. Proposal number 7. Okay, so again, proposal 6 concerns temporary restraining orders. Proposal 7 concerns preliminary injunctions. Preliminary injunctions are a little bit more deliberative. There's more process that happens. So here's a proposal. Cases seeking a preliminary injunction or equivalent relief against the federal government or a state government are not decided by a single district court judge. Instead, they're referred to the en banc court. Ooh, different. And the en banc court then randomly draws a 3-judge panel, okay, with 2 circuit court judges and 1 district court judge. So again, when you seek a preliminary injunction against the federal government or state government, the en banc court, not the chief judge, the en banc court appoints a randomly drawn 3-judge panel with 2 circuit judges and 1 district court judge. This is not a new idea. For much of the 20th century, these 3-judge panels resolved constitutional challenges. Perhaps most famous is Williamson v. Lee Optical, a case we all study in law school, was originally decided by a 3-judge panel, which found that the Oregon licensing law was unconstitutional. Say, so why the en banc court and not the chief judge? I got a bit of a beef with the chief judge. How do you become a chief judge? Not through merit, not through quality, through age. Is you have to be old but not too old. It's a gerontocracy. Or you have to be the most senior judge who's not over the age of 65. It's not a very useful system. So some chief judges are great, others are not. And I don't know why this person should have all the power to appoint 3-judge panels. Out of the full court, do it and make it random. Okay. And then why 2 circuit in 1 district rather than 1 district and 2 circuit? Most of these issues, these preliminary injunctions, are legal, right? They're matters of constitutional law or statutory interpretation. That is a skill set I think that is better suited to have a circuit court judge. There's less likely to be a trial, less likely to be procedural issues, and I think having the circuit judges look at this sort of cuts to the chase quicker. But here's the key point. You don't go from this 3-judge panel to the circuit court. The purpose is to skip the circuit court. Which brings me to proposal number 8. Injunctions of statutes from these 3-judge panels are automatically stayed. Okay? Injunctions of statutes from 3-judge panels are automatically stayed. What does this mean? If Congress or a state enacts a statute and this 3-judge panel issues an injunction, there's a stay. Why? A presumption of democracy. If there's a legislation act that passes through bicameral presentment, a 3-judge panel can stop indefinitely. By contrast, let's say there's an executive action. Either the president or perhaps a governor takes some executive action, and the 3-judge panel enjoins it, there's not an automatic stay. This obviates the need to run to a higher court to seek relief. And I'll just give you an example. In the One Big Beautiful Bill, Congress defunded Planned Parenthood. This was a statute. This was not an executive action. It was a statute. Somehow, a judge in Boston, I swear to you, found this was an unconstitutional bill of attainder against Planned Parenthood. Lunacy. She enjoined a statute to require the government to pay Planned Parenthood money because it was a bill of attainder. Lunacy. And then the government had to run to the circuit court to seek a stay. Why? If some lower court judge loses their mind, put a stay in automatically. You shouldn't have to waste time for this to go into effect. Okay. But what happens after this injunction is issued? Here's the rest of my proposal. If the three-judge panel submits what we call a certificate of division, the case is an appeal to the Supreme Court's mandatory jurisdiction with oral argument and decision on an emergency docket timeline. So in other words, if this three-judge panel says, look, we're ruling this case, we're putting an injunction, but this is an issue in which there's division among the circuits, it goes right to the Supreme Court, skips the circuit court. This avoids the folly of 5 different district court judges at the same time resolving the same issue, which happens all the time now. Judge in Boston, a judge in Rhode Island, a judge in Brooklyn, a judge in San Francisco, and so on. You obviate that. And you have to get this done very quickly. The goal is to not sit around and create this sort of multiple split of litigation. Okay, again, if the panel is divided, if it goes 2 judges one way, 1 judge the other, certificate of division, then it goes to the Supreme Court's mandatory jurisdiction. Okay. Proposal number 9. This one I think is a little bit creative. What happens if an en banc circuit court or a state Supreme Court thinks this is really an issue for the U.S. Supreme Court? They can't really do anything about it. And sometimes lawyers will say, oh, the circuit court said this was very important. Supreme Court, please take it. And the Supreme Court usually ignores them. So I would flip the dynamic. En banc circuit courts and state courts of last resort can refer cases to the Supreme Court's mandatory jurisdiction. How? They can submit what's called a certificate of split. That is, a split of authority on questions of federal law. The judges can also submit a certificate of importance. What's that? If there's some exceedingly important and unresolved issue of federal law, the circuit court can certify this. It's very often the case where Supreme Court cert petitions lie about, or say exaggerate, I should say, about how much of a circuit split there is. And the other side says, oh, there's no split at all. I would let the judges themselves describe whether there's a split. And I think this would ensure that urgent matters go to the Supreme Court quickly, and the Supreme Court's not dependent on zealous advocates who might exaggerate or the opposite of exaggerate, downplay the significance of a case. All right. Proposal 10. Judges hate this one, so I put it last. We have a problem of judges who stick around too long. It's a problem. I suppose none of us can realize when we become frail. I think that's part of human nature. People are not good at succession planning. It's just we're not good at it because we think we're always going to be able to do our job. In recent years, some justices have died in office. Ginsburg, Scalia, Rehnquist. Other justices have stepped down before they died. You have Stevens, you have Breyer, and you have Souter and Kennedy. But lower court judges tend to stick around because there's not really any pressure upon them. And I don't blame them, right? It's a cushy gig. They can pick these amazing law clerks. They don't do terribly much work for some of them. They can coast a bit. So the current rule for retirement concerns the rule of 80. And just to make it very simple, if a judge is at least 65 years old and they have at least 15 years of service, that's 65 plus 15 is 80, they meet the rule of 80. They can then retire with 100% pension for life and take senior status. They keep the same salary and get to do less work. They can do no work at all and retire outright. They keep their salary. But judges often delay taking senior status. Judges also are strategic, and I don't mean this as a criticism, but it's a fact. Democratic appointed judges tend to take senior status when they're Democrat in the White House. Republican appointed judges tend to take senior status when Republicans in the White House, unless his name is Trump. As it were, many judges are not taking senior status because I don't know why. They don't like Trump, whatever. I would take this discretion away from them. So this is a little bit complicated, so just follow along here. What happens when a judge hits the rule of 80. Under my proposal, two things would happen. First, a circuit judge who hits the rule of 80 can no longer sit in en banc proceedings. Perhaps the most important thing to many of these judges, the en banc court, they can't do that anymore. Second, and this will be by statute, a new judgeship is created which will be filled immediately. Judges who hit the rule of 80 have no leverage over who fills their vacancy. Judges would not be called senior status, but they would be in everything but name. Judges tell me this is unconstitutional. It requires an amendment to the Constitution. I don't think so. I don't think there's any God-given right for circuit judges to sit in an en banc court. That's a modern procedure. And I think Congress could limit en banc courts to, let's say, the most 15 junior judges on the court. And nothing prevents Congress from creating new judges by statute whenever certain conditions are triggered. Um, you would also know exactly when a judge is eligible, and this would be useful in trying to fill vacancies because in certain circuit courts, judges never take senior status, and seats can be remain unfilled for decades. All right. So I'll just close by making a few points. I'll turn to Q&A in a minute if you want to bring your questions in the queue. I think this product of bilateral judicial reform is equal parts ambitious and naive, which might be epitaphs on my tombstone. Um, these proposals probably will never go into effect. I have a lot of grievances, there are a lot of kinks, but I hope that these proposals have foreseeable consequences, right? The court should expand its mandatory jurisdiction. They're not taking enough cases. Uh, Lower court judges should take senior status earlier. They're hanging on for far too long. Um, there should be a more standardized timeline for emergency cases. I think a lot of the criticisms would fade. But if we just speak about reforming the courts of how to help the right or the left, really nothing of any usefulness will get done. All right. I will stop there and I welcome any of your questions. Thank you so much.
Thank you,
Okay.
Josh. My gosh, I think any of those 10 could have been, full law review articles by themselves, but you decided
Sure.
to, in like an
It's something like an exhortation, just get it all out to be
Yes.
considered. As a reminder to our attendees, you're encouraged to use the Q&A feature to submit questions. I'll get us started, though. If I had to kind of put a umbrella question over all 10 proposals, it might be this, that there seems to be coming more from the left than the right at the moment, but that's not to say that it's always historically been the case, a question over the legitimacy of the Supreme Court. And the left obviously is enamored with calls to pack the court to address this so-called legitimacy crisis. Why do you think your more modest reforms, because all of your reforms, as ambitious as they are combined, would not change, the quote unquote legitimacy of the court more than if we engaged in court packing of the Supreme Court? In what ways would your 10 proposals, if any of them were even adopted, address this so-called legitimacy crisis?
Yeah, so I'm a fan of Justice Scalia, who used to say the law of rules, I'm sorry, the rule of law is the law of rules. I like rules. And right now the Supreme Court doesn't have many rules. So I take it a fair aspect of the Supreme Court shadow docket, or at least the criticism of the shadow docket, is they make up the rules as they go along. Justice Jackson called it Calvin ball, and I think that's unfair. That's not a fair description of what the court does. But if there was a clear path to get a court to the emergency docket and a clear timeline of how to resolve those disputes, I think it would breed some confidence that they are following rules and not just making it up. Because in some cases they resolve things right away. Other times they sit on for months a month at a time. That doesn't breed confidence. I also think, and this is something I feel very strongly about, the justices need to be seen as responsive. And if the lower courts are saying we need help on these issues which are not illogical, and the court denies everything, that doesn't help legitimacy. One of my ideas, which I didn't mention if I didn't have time, is the court goes in a roadshow, right? Every year they hold an oral argument sitting in another city. Go to St. Louis, go to Cincinnati, go to Denver, go to San Francisco, right? Go to Chicago, go to Atlanta. Go to New Orleans, right? Let the people see them as not these oracles, but as just regular folk. And I think when Justice Barrett goes in the stump, she makes a good impression. And I think they should do more joint events. I think they can do a better PR thing. I think the Chief Justice fails in many regards, but he never has a PR platform. He releases these statements which no one reads. Let them be seen. Let them. They're not oracles. They are human beings.
Oh, I've always, myself held that when the justices conduct interviews, they more often than not are successful at demystifying
Yes.
the work of the court, and how they think about the role of the judge, rather than having uh, you know, interpretations of their work from the Supreme Court chattering class. No doubt. The other theme that I think is apparent from your proposals is just in general, make SCOTUS work harder.
Yes.
And um, perhaps you could do a riff on why you think that it's not just that these are very capable people and now they're in an institution which is hearing fewer cases per year, that allows you to make that proposal that they could be working harder. Um, but perhaps go from that, argument that they could be working harder to that they should be working harder, and tell us why that addresses perhaps the legitimacy, the so-called legitimacy crisis.
So the Supreme Court has complete control over its docket, and they've had that since at least 1925 and more in the 70s with the certiorari writ. And the number of cases being decided decreases and decreases. The fewer cases they have to decide, the more time they have to navel gaze. All right, these very long concurrences which no one reads or cares about, and they have less time to actually resolve cases cleanly. If you look at the time when John Roberts clerked, the court would decide almost 200 cases a year, right in the 1980s, and now they're down to under 50. And Justice Barrett made a comment. She says, "Oh, we don't grant many cases. There are not many cases worth granting." And I just think that's lunacy. I can't see it, but maybe from their vantage point, oh, these cases aren't these important. All these lower court judges can figure this stuff out, but they truly can't. Now, the second half of your question, which is true, is I think the justices need to retire younger. I truly believe that. And it's not pleasant to say. I think Justice Stevens stayed on for too long. I think Justice Ginsburg stayed on for too long. I think Justice Scalia stayed on for too long. I mean, he didn't make it through the next administration. He could have retired during the George Bush administration. He didn't, and he stuck around. And I'm thankful for the opinions he wrote. I mean, look, Justice Thomas, he's a living legend. He's playing dangerously. Justice Alito, right? Anything could happen. If he's replaced by, a Biden judge, what the heck's going to happen? Um, if you make the workload higher, it creates natural incentives for justice to step down. It's inevitable. The more work a person has, the more clear it is they can't do it. Um, I the chief justice has all these administrative responsibilities. That's a lot of work, and it might get to a point where he can't do them anymore. Maybe we'll have to step down. Who knows, right? I don't think it's a bad thing to give them more work. I think if they write fewer books and write more opinions, I think we'd be much better off.
I have a question from one of our co-panelists, Jordan Balor, who asks, can you say a little more about the different branches and their disincentives or incentives, responsibility for addressing reforms like these? Which ones could the courts simply do themselves? What are the obstacles to the courts taking these actions on their own? And which ones require Congress or the executive or both?
Right. So the biggest obstacle for congressional reform is just politics. And I'll just give you an example, which I alluded to earlier. There was a judge's bill which passed both houses of Congress in 2024 before the election. And it would have created a bunch of new judgeships in places where there's an actual emergency. We need district court judges there. President Biden sat on the bill and sat on the bill and then vetoed it almost shortly before his term ended, or at least his auto pen vetoed it. I'm not sure who actually. It was vetoed. Who vetoed? I couldn't tell you. Um, and the reason why is he lost the election, and he worried that this would now give President Trump some new judges. And again, this would be phased in over years. But yes, Trump would have had some appointments, and he wouldn't give it to him. That was a disappointment. Bipartisan legislation. I think any time we're talking about Congress, it's each side's looking to get an advantage for their own party. And that's just the nature of politics. You can't get around that. So what I tried to with this article was think very deeply about what are things that neither side could object to, that both sides would actually think, oh, that's a good idea. That doesn't give any advantage to any side. Um, I'll give you an example. Some proposals would give the DC Circuit a mandatory review of certain constitutional cases. That sounds neutral, except the DC Circuit leans far to the left. Why not the Fifth Circuit? You could do this many different ways. Other proposals would, you know, expand the Supreme Court's emergency docket discretion. Well, the Supreme Court currently leans to the right, so maybe that's not a good idea at all. In fact, I think the biggest vulnerability of my proposal is giving more cases to the current court would give the conservatives a bigger majority. One idea that I've seen around is to have a law declared either constitutional or unconstitutional. You might need instead of 5-4, 6-2, 6-3 vote, or 7-2 vote, right? There are different voting rules you could adopt, short of court packing, that could achieve the same goal. So I think you have to be very strategic. I don't know if any of these proposals will have any juice. I think they probably won't, but I think they're useful to sort of think about as a way to get in the right mindset.
So I noticed in one of your proposals about the nationwide scope of a regulation as opposed to the nationwide scope of a statute being subject to a preliminary injunction, the distinction that you made between a presumption of democracy cutting in favor of staying a proposal, staying a ruling versus a presumption against an executive order or regulation, and therefore, the judicial intervention, if you will, cutting in favor of putting the injunction into effect. It seems that that would be one that would hew to vacatur in particular, having Congress's blessing, because vacatur was established in the APA for statute. But do you think that there's enough sort of like gray area where, look, like Congress needs to speak very clearly on this distinction? Either it meant what it said in terms of vacatur, indeed, having nationwide relief for a regulation that's nationwide in scope, or something else. Just because I think that this one's a live issue, particularly after Trump versus Casa. This difference
Yeah.
between vacatur and the relief that an amended Rule 65, as it's now understood, entails.
Oh, good question. A lot of those packed in there. So, in fairness, I wrote this paper before Casa, so I guess it's somewhat obviated, but not really. Um, I see the difference between a national injunction vacatur less about the APA, more about democratic accountability. And when we think of a statute, those are hard to pass, right? It's bicameralism presentment. There's a filibuster in play. There's a very strong tinge of democratic legitimacy there. With executive actions, you have far less. So in the classical sense, you might have a full regulation with notice and comment and rulemaking and everything else, and that seems somewhat better. Although I think rulemaking is notice and comment is kind of a waste of time. They don't really care. Some of these policies are created just by the executive signing a pen, like DACA or something very significant. Um, Even the state system, state governors can take executive actions as well, which rely on dubious assertions of executive authority. There was actually just an opinion on Friday night by the Supreme Court in the transgender passport case, where the Trump administration enacted a policy to not allow people to like put different gender identities in their passports, only their biological sex. Um, and Justice Jackson made a point saying, this is not an injunction to allow statutes to go into effect. It's an injunction to allow an executive order to go into effect. And she said an executive order, she actually wrote, lacks the force of law, which is not correct. I don't think she meant that. I think what she meant was it's less law than a statute. And I actually agree with that in the abstract. That's not the courts. The courts have said an executive order is law, period. So I think Jackson stumbled onto the truth. It happens every now and then, right? a broken clock twice a day, as they say. But I think she stumbled into the truth. But I freely admit this is one where some conservatives may not like it in the current moment because this would not grant automatic stays for the Trump executive orders. But look, in the last administration, when I wrote this, this would have granted a temporary stay for every order that Biden issued. So you have to sort of think long term, which rule would benefit the law in the long run. And I think Democrats tend to be more aggressive with executive actions without statutory grounding, although many people disagree with him on that one. But in terms of the vacator versus set aside, uh, I think Sam Bray has convinced me that vacator is not a thing. I think it's kind of just made up by the DC Circuit and some of their judges. I also think that Justice Kavanaugh and Chief Justice Roberts and probably Barrett don't agree with, or maybe Barrett does agree with Sam, but at least Roberts and Kavanaugh don't agree with Sam on this. So I don't know if there's votes to kill it. And I think in the current moment, the court's liberals would never vote to kill vacator because it's the only way around it. There's also the issue of class action Rule 23, which has just exploded in the wake of CASA. So again, I think I'd focus less on the automatic stays and more getting the Supreme Court quicker through a sort of standardized timeline.
Fascinating. Okay. We have another question. This one from Justin Smith. Justin would like to ask it orally. Daniel, could we please unmute Justin Smith's microphone, and he's going to ask his question?
Great. Thank you so much. Professor Blackman, you've done such a great job of formulating these proposals from admittedly a bilateral perspective. But, I'm just curious, if you could wave a wand and, if you acknowledge simply that, they're unlikely to be implemented, do you have any reforms that you would put into place that are, arguably more blatantly unilateral?
Oh boy, that's a good question. I think I would probably. I have one idea. I actually have an article I'm working on called Unilateral Judicial Reform. So it's funny you mention that. But this is stuff that what a Chief Justice could do by himself. So just hang with this one. Um, I think it's a mistake that the Chief Justice always presides. On many other courts, the position rotates. So in some state Supreme Courts, you can actually vote every 2 years for the Chief Justice. In other cases, you can move out of it. Let's say the Chief Justice is absent, that someone else can preside. So for example, when Justice Rehnquist was sick, Justice Stevens presided. I would have the Chief Justice position rotate each month. So each month of the sitting, by a random draw, another member of the court would preside. And I think the Chief Justice could do this on his own. I don't think you need a statute. I think John Roberts could say tomorrow, hey, okay, let's pull numbers of a hat. All right, Clarence, you're October. Katanji, you're November. Sam, you're December. And that person presides not just over the oral argument, but also the conference. And with that comes the assignment of opinions, which is very significant. Not significant as you might think, but I think it does have some weight. I think that would give more buy-in because I don't think the justices are currently happy. I think the end of the day, oh, we love each other, blah blah. Yeah, yeah, right. I think they're frustrated. I think this would give them all a sense of buy-in to the court, and also it would let the people see that someone else is not in the middle seat. And I think that would send a very positive message. Um, this would also allow the Chief Justice to focus on cleaning up house and fixing a lot of the other things that are wrong. I would also have the court do a monthly press conference. I hate leaks. Oh man, Garrett knows this. I hate leaks. I would let the court do a monthly press conference and stop doing these interviews behind curtains in closed chambers, where only one member of the press is present. Do it public. Address these questions, right? Have a press conference on the leak. We still know who leaked the Dobbs opinion. It's embarrassing. And we have this silly statement that, yes, we cannot prove who did it. And Leo's like, I know who did it.
Yeah,
Like,
yeah, yeah, yeah.
be accountable. So I would, again, do things to make the court more accountable. And that might be unilateral. So hope Justin answers your question.
That
Yeah.
does sound like a rather Cincinnatus-esque move if the Chief Justice could do it. My only concern is that Congress, the Senate, confirmed the office or the person to the Chief Justice role. I wonder, is this even possible though? Could the Chief Justice unilaterally do that? Like, wouldn't that be a ground for the Senate to sue that its will has been usurped?
I don't think the statute says anywhere that this person must preside every position. It's just called Chief Justice. His only duty is preside at presidential impeachments. I actually, I mean, well, so Tillman and I have written that that Congress can even designate another person to preside impeachment. It doesn't have to be the Chief Justice. It does. I can be a different person. That's a project for a different talk. But I don't see anything wrong with it. When Chief Justice Rehnquist was sick, Justice Stevens presided. There was no constitutional violation, right? The court doesn't
Mhm.
stop functioning when the chief is absent. When Rehnquist died, we had an alternate presiding officer. I don't know if Roberts ever not presided. I can't think it's ever happening that I can recall. But I think with the consent of Congress, look, if Congress wants to pass a statute, I think they would. I don't think anyone actually wants Roberts in this forever. The president might be upset by it, so he might vetoes it. But I don't think you need a statute. I'm working on a blog post with this thing.
I mean, it's fascinating, especially if you would change the kind of like administrative role of the Chief
Exactly.
Justice, and separate that out from the presiding role.
Yeah, they
Yeah.
don't have to be the same. Indeed, I would, I would make Roberts resign from the board of the Smithsonian. I don't know why the Chief Justice is there. Do you know the first chief who presided over the Smithsonian was? Roger Taney. He took
Oh,
that responsibility. There's not a good history there.
I didn't know the Smithsonian was that old. Wow.
It is. No, it was created before Lincoln. Yeah, in the 1840s, I think. Um, yeah, I would strip the strip is a harsh word. I would have the Chief Justice give up a lot of the other responsibilities and focus on the actual administration of the court and presiding over argument. I've heard this, Garrett, and we're just listening like friends here, of course, being recorded. I've heard the chief has made a lot more mistakes recently with presiding. He's skipped people in the round robin format. He's called in the wrong person. The job is taxing. I mean, when I keep saying he should retire, I don't mean just facetiously. I think it's a lot of work. And I was at the court last week, and he called on Justice Sotomayor, and then he looked at Justice Sotomayor and Justice Kagan. He confused Kagan and Sotomayor, and it was kind of weird. And Kagan's like, "I'm Justice Kagan," so that stuff happens. But I think we should make the Chief Justice less great again. Is that a thing? I don't know.
Hello, everyone. Hello, Professor Blackman. I'm curious to know if there's any inspiration that you might take from how the various 50 state court systems run their courts,
Good
and
question.
whether or not there's any differences. I think, for example, of course, in Texas, we have the Court of Criminal Appeals, which, specializes in criminal appeals versus the Supreme Court of Texas, which specializes in, of course, everything else, all the civil trials. Are there anything like that that you think might be portable to the federal level that would be a useful reform?
Yeah, in fact, the idea of having the Chief Justice rotate is a proposal from Utah. On the Utah Supreme Court, Justice Tom Lee used to be there. They would vote on a Chief Justice and a Vice Chief Justice, who then presides. If the chief is absent, the vice can step in. I think it's actually a very useful proposal. Um, I also think that in a number of states, they have automatic stays. So in Texas, this is actually where I got the idea from. Uh, if any judge, let's say in Austin, enters a TRO against a Texas statute, by virtue of filing a notice of appeal, the government automatically gets a stay. So the Texas AG doesn't have to ask for a stay from the Supreme Court of the state or the Court of Appeals. Anytime there's a basic injunction against a state statute, the stay is automatic. I got that straight from Texas. So I think there's a lot of things you can learn from our 51 imperfect solutions. Um, and again, a lot of these things I think could be done even through the federal rules of civil procedure. We may not actually need statutes. And again, who presides over that? The chief. So I think there's value in having this rotate. I think having one person have the same position for a long time is never a good idea. John, someone said the other day, the chief justices tend to die in the seat. Well, imagine if John Marshall had stepped down when John Quincy Adams was president instead of dying when Andrew Jackson was president. We would never have Chief Justice Taney. Maybe never have Dred Scott. I mean, it's actually not even true. Berger stepped down, Warren stepped down, and several others stepped down. So I think Hughes stepped down. So it's actually not true. But this wasn't my theme today. But I can't quit it.
Well, again, thank you so much, Josh. To lead us out, it's my pleasure to welcome back Dr. Jordan Ballor for some closing thoughts. Jordan?
Yeah, just very briefly, thanks so much to Josh for that fascinating presentation and the preview, hopefully, of maybe an upcoming one on unilateral judicial reform. So looking forward to that. Thanks so much for taking the time today, all of you who joined us. As always, it's great to partner with James Wilson Institute to put these CLEs on. We will have one for December. We don't have the details yet, but you can look for for more information in your email inboxes or on the web, wherever you get that information. So thanks again to Professor Blackman, and have a great day, everyone. Thank you so much.
Thank you, everyone.